Thanks very much for welcome back. Our second panel today is on privacy and digital surveillance. David Fraser is a partner at McInnes Cooper as well as an adjunct professor here at Schulich. Andrea Slane is a professor of legal studies, graduate program director for the Master of Arts in Social Practice and Innovation within the Faculty of Social Science and Humanities at Ontario Tech University. And Tamir is the director of the Privacy, Surveillance, and Technology Program at the Canadian Civil Liberties Association. And our moderator, Jonathon Penney, is an associate professor and York Research Chair in Artificial Intelligence, Data Governance, and the Law at Osgoode Hall Law School. John, over to you.
Yeah. Welcome everyone, and yeah, I think if you want to move around and sort of generate some heat, that's also sort of welcome at any point during. So if you see people getting up and moving around, I'll understand. It's not because you're disinterested in the topic of privacy and surveillance. You're more sort of keeping warm, which is all good. So. We've got a great panel of experts on a topic that I feel like each of the sessions that we've had yesterday and today, issues of privacy and data protection. It's like the salient, persistent issue, and it relates to a lot of these big concepts that we've heard around trust in government, trust in media, trust in mainstream institutions, and privacy today is under threat. And you've heard this, you've learned this, it's been talked about, and we'll continue having that conversation today due to unprecedented forms of technology in government being utilized by private sector companies. And governments are struggling with it, academics and experts are struggling with it, and we're going to continue having a conversation with some excellent experts up here, thinking through some of the challenges for today. And so I'll start off with some more open-ended questions for each of our experts. And I'll start with David at the end, just at the end here. David, you're one of the country's leading and most recognized names in terms of privacy law, as a privacy lawyer. I'd love for you to sort of start us off and give us your thoughts on how privacy law and digital surveillance and the landscape has changed over time. And of course, if you, in your answer, if you want to also talk a bit about something that you're working on today that sort of addresses those changes or a pressing matter today, feel free to also jump in on that.
Sure, and thanks so much for the opportunity. I think, like so many things, changes in technology have just altered and made more acute many of the issues with respect to surveillance. Rather than kind of going dark, which we've heard from law enforcement related to encryption, in some ways that they're kind of just buried in data, and the potential for data collection for surveillance purposes has just exploded. And I think in the background, and one of the problems that exists when you connect it to kind of privacy laws or other forms of laws is generally a lack of transparency and oversight and accountability. And if you think of just in terms of the way that technology has changed, for those in the room who have gray hair might recall going to a bank in the 1980s, 1990s, and maybe seeing two cameras, and they were the size of microwaves. And so the cost of a camera, of a surveillance camera, was extremely high. And so they were only used in circumstances where there was kind of very high risk, where the investment was worth it. And now you walk through any shopping center and you're going to see, if your eyesight is good enough, you're going to see dozens and dozens and dozens of cameras, and they're smaller and smaller and smaller and smaller, and they're everywhere. And they're being deployed so readily, not because the world is way more dangerous than it was 15, 20, 30 years ago, but because they're so inexpensive, and because everybody has them. And the kind of imagined situation where if one store had them and the other one didn't, the one that didn't might be a greater target for shoplifters and other things like that. But at the same time, so everybody's walking around with one of these devices, and cops are quite keen, because all of your communication is going through a smartphone. And your smartphone not only contains all your communications and all your banking information, things like that, it also cheats your location. It also lets the world know, it certainly lets the cellular system know kind of where your particular device is. And so there's information that the police, if they're investigating a particular incident in a particular place, are going to be, and one of the first places that they're going to go and look, or that they're going to try to look, is cell site location information. And at the same time, you have other technologies, and this is the thing that I think is probably the most problematic, are the kind of more innovative uses of law enforcement technology without any oversight and accountability. So you think of, for example, stingrays, which are cell site simulators, which police can deploy. It pretends to be a cell phone tower, so every cell phone in the area connects to it, thinking that, hey, here's a tower I can connect to. Your phone is pretty promiscuous. And that tags information related to the particular device. And that information can then be connected to an individual with a production order or an assistance order under the criminal code. And then you look at the combined use of surveillance cameras with additional new technologies like face recognition and face matching. The one thing that makes me less worried about all the kind of surveillance cameras in a shopping center is that they're generally not networked together, and each store manages their own system. But when you put them onto a system where law enforcement have unitary access to it, and can just go in and grab images of individuals going through their day-to-day lives, and then you pile on top of that a facial recognition system, which are significantly deployed in public places in the United Kingdom, not so much in Canada, but you have vendors like Clearview AI who scrape images off the internet in order to create facial recognition databases to sell to law enforcement, and that comes out through the media, not through the RCMP. The RCMP initially denies that they've ever used it, and then they're revealed to have been customers, or at least doing a pilot project of it, and now, at least after a Privacy Commissioner investigation, have been told not to do that anymore. And we also understand that, and some things have come to light related to, for example, the RCMP use of what they call audits, which are on-device investigative techniques, which is essentially remotely hacking into smartphones, not only to get access to the contents, but also to be able to activate the camera and the microphone on these things. So turning it into a mobile device. There was certainly no public announcement that they were planning to do that. There has been some investigation into their activity, all of which calls for, hey, greater transparency and accountability, and who's deciding whether or not this is appropriate, and in what particular cases. And also the flip side of that is that if they can if they're taking advantage of vulnerabilities to hack into phones, they are aware of vulnerabilities that bad people could use to hack into phones and are not doing anything to remediate that. And so I think those are some of the things that where the technology moves, the surveillance capability moves. I don't think the oversight, accountability, and the law has done anything remotely to kind of keep up with that, other than judges on a case-to-case basis applying Section 8 of the Charter when it ends up in front of them. So.
Okay, that's great. There's a lot there, and we'll come back to when I said at the outset, privacy is under threat. I think David has sort of laid a strong groundwork for that. We'll come back to that. Let me move to Andrea. Andrea, your work really touches on some of the most pressing matters and issues in privacy and data protection. Let me ask you, what is something that you're thinking about today or working on in the context of privacy and surveillance?
Yes. So thank you, David, for setting the stage. So I have been working on governance and oversight questions in the wake of the Clearview AI scandal, which really sort of brought to the public attention big questions about, what are the limits that we should impose on police use of certain kinds of technologies, and where is the oversight? It was clearly lacking in that use of that particular technology, or even the testing of that particular technology. There was a lot of activity in the aftermath of the disclosures that this privacy-offensive technology was in use in ways that lots of people, even within the police services, weren't aware of, the police leadership wasn't necessarily aware of, and there was really no oversight of acquiring or even having any kind of contact with a privacy-invasive technology like that. So, we did have the privacy commissioners banding together and coming up with some guidance, investigation into the RCMP use of that particular technology and investigation into the company itself. We had the Ethics Committee doing hearings about AI technology use in the public sector, but a lot of it being on law enforcement, and we had civil society coming up with a lot of complaints and concerns, and for the most part hoping to influence law enforcement in the public sector to just not use things like facial recognition technology, but then also coming up more recently with guidelines and saying, well, we really still don't want you to use it, but if you do use it, now here's like 18 different things that you should do to make that more privacy protective, more rights protective in a more general kind of way. So what I've been doing since then is looking at, like, the Ontario Information Privacy Commissioner came out with specific guidelines about facial recognition technology use with mugshot databases for a very limited, specific kind of use. And they were requested to do that by police services, some of whom were already doing that anyway. They were using a product, and some of whom wanted to adopt it. And they have done that, and the police services that took them up on those guidelines have hewed relatively closely to the guidelines that they came up with at the Ontario IPC. These are basically large police services in the Greater Toronto area, and they have embarked on trying to fill a gap because we don't have clear legislation, we don't have clear guidance from courts, by internal policies and procedures. Some of that involves, when it's policy, some of that involves involving the police service boards, the civilian oversight, to have some sort of role to sort of see whether or not the policies are being implemented properly, some sort of reporting mechanisms, all of those sorts of things are in their sort of general governance kind of principles. Sometimes they have procedures, sometimes they're bigger policies that govern AI tech use and adoption more generally, sometimes they're very specific to facial recognition technology use with mugshots, but there's not a lot out there. There's really just a handful at this point. But what I'm interested in is, so the police service boards also got more responsibility due to the 2019 Community Safety and Policing Act, which only came into force 5 years. They got 5 years to figure it out. So that came into force in 2024, and it gave police service boards a little bit more authority, but they're not very well equipped to actually implement that oversight that they've been given authority to invoke. So they're responsible for ensuring that each municipal service provides adequate and effective policing, and they're supposed to do that through their sort of interaction with the police chief, who's still responsible for the sort of operational implementation of all of these sorts of things. So one of the things that I've been trying to track is how they've been dealing with facial recognition technology and other artificial intelligence technologies through the development of board policies and police service procedures. But then also, I've noticed that they've tried to do this kind of transparency-like thing by communicating things about their use of different technologies. Some of it facial recognition, some of it AI more broadly. Sometimes it's automated license plate readers. It's a bunch of different kinds of technologies, and they'll have policy information on their websites, often through like an FAQ type mechanism, but very rarely actually linked to any kind of documents that would be saying, okay, here's your policy or here's your procedure, and contacting the police service board to see if they're properly overseeing that. So one area that I'm really interested in, especially now, is, Clearview, we pretty much got off the table as something that was not going to be permissible. Facial recognition technology used with mugshots seems to be happening, so that's going on, whether you like it or not. And then there's these efforts to distinguish other types of face matching technologies from what we call facial recognition technology. So they're video analytics, image analytics kind of technologies that police services who were wanting to use those, they basically take like a large amount of video that they get from all these different sources that are sort of coming in from CCTV, from body-worn cameras, from like all these different things, and they can identify objects. Among the objects that they can identify and like give you timestamps for, so you don't have to watch the 120 hours, is a face, right? So some of the police services will say, we've turned that feature off because they want to, keep a big distance between themselves and what we've come to sort of dislike about facial recognition technology. But there's increasingly some movement towards turning that back on, more or less. Not calling it facial recognition technology, but basically just saying all it's doing is an efficiency type thing. It's giving us all these timestamps, and then, as Teresa was saying in the last panel, that a person has to look at the various moments where this face appears in this video, and that's one of the safeguards in there. The other thing that's going on is the Ontario government has provided a lot of money for police services to purchase technology, including more CCTV cameras. So there's a specific grant. So there's smaller police services, smaller municipal services have money to purchase more cameras. They have more money now to purchase more technology. And their police service boards are especially not equipped to do the oversight because there's not a lot of history behind sort of what the competencies are to be able to properly oversee the implementation of these types of technologies. So that's the space that I'm operating in. It's like kind of this, there's a lot going on in the absence of like greater direction from federal, provincial governments and from courts. And so I'm really like digging deep into like, police service board minutes and agendas and watching recordings of public meetings and sort of, listening to the presentations that police chiefs are making to their boards about their technology use. And so that's where the action is as far as I understand, like right now. And that's what I'm doing. Yeah.
That's a lot. That's that's significant. Thank you, Andrea. And we're going to come back to some of these issues as we get into our sort of Q&A dialogue here. But let me just move to Tamir. Tamir, you've been fighting in the trenches for privacy and law and advocacy for many years. First at CIPIC, now at the Canadian Civil Liberties Association. What's an important privacy project that you're working on now that you'd like to share?
Sure. So,
Wrong one.
Maybe,
yeah, we got to share.
You can have mine. Yeah.
Thanks. I'll give it back. Don't worry. So, sorry. There. Oh, it's actually okay. Here we go. Okay. So, thanks for the question and thanks for having me here. I'm often finding it hard to find time these days to work on anything that could be characterized as a project because we're so busy reacting to so many different privacy incursions that are coming at us in multiple different ways. But one project that I'm specifically excited about that we've recently been engaging on and relates to a lot of the things that my colleagues are talking about is also focused on trying to get some police accountability around the use of emerging technologies and very specifically focused on AI. So the Law Commission of Ontario, which is an independent body that does basically puts out standards and considerations of different types of public policy related to law, is looking at the use of AI in the criminal justice context in Ontario. So it's something that we've recently started engaging in and are trying to feed into. And through this vehicle and other vehicles that are less sort of project specific and more sometimes reactive to things that are just coming up in the media, we're trying to create a more shape a little bit the framework for how policing forces should be dealing with these new tools as they emerge. and trying to address some of the challenges that my colleagues mentioned. And we're seeing a lot, and it is very challenging, and a lot of the tools that would be needed to address this, the regulatory and legal tools that would be needed to address this are not something that, are things that the Law Commission of Ontario or that civil society groups or academics can recommend, but would need some sort of political will to put in place. And a lot of these, and what we've been trying to stress for policing forces is that there are some types of technologies that they should just not be adopting until some of these tools are in place. And others that could be, we also tend to adopt, though, in these discussions, a kind of a harm reduction framework. So we try to also address some things that could be done to maybe mitigate, mitigate how, if technologies are adopted, kind of mitigate the worst implications of them. So through that lens, we're trying to understand what is and isn't working in the current infrastructure. And one of the things that we've looked at specifically is, for example, how police board policies are actually playing out on the ground and how they're being applied by different police oversight boards. And we've seen some issues here. So I'll just give one example. Where we're looking at, this isn't in Ontario, but this is in BC. But there's a policing force so they adopted a use of a fleet of drones, and they adopted a policy that had very specific limitations on when those drones could be used. And it specifically set out, and this is their, when they were adopting this, their public justification and for adopting these was that there's going to be this policy in place that the police board put in, and it said specifically things like, you can't use these drones for surveillance. You can't use these drones for peaceful protests, and it had very explicit limitations of this kind that looked very robust. But then when it came down to how these were used, the drone fleet was used 3-4 years later when there was political protests that the police wanted to use the drones for. Suddenly their interpretations of these very clear limitations evolved. So, and then we learned, there was a complaint filed by colleagues of ours in BC to the police board, and their decision in applying these restrictions was that surveillance actually just means covert surveillance and not overt surveillance. So you can still use drones for surveillance as long as people can see the drones, which is an interesting interpretation of the term. And then they also said that it's actually okay to use drones to record anyone that the police considers is no longer, or may potentially not be peacefully protesting, as long as you're not capturing too many other people in the image. And then their other creative interpretation was that when you're recording people at protests, as long as you're not really focused on one person, then that's not personal information, and that doesn't count as also either surveillance or monitoring of a peaceful protest. So these really creative, what to us seemed like really creative interpretations of what seemed to us, at least when the policy was adopted, to be clear-cut restrictions. It's a concern because it allowed this technology to be used in a way that's really chilling and could have really significant implications for people who are participating in political protests that were predominantly peaceful. But it was also concerning to see this type of creative reinterpretation of a policy that seemed fairly clear-cut when you read it, through the lens of a very sort of, how do we allow this to police, the board looked at this through a lens where they were like, well, the police are doing this, and it was very clear that this was just an exercise in trying to justify what was already happening. And the challenge is, there's no independent appeal kind of mechanism for these boards. So you're basically if that's what the board comes up with, that's what you're left with. In other instances, though, these types of policies are very helpful and do actually shape up. We think of them as harm reduction, so they're worthwhile, getting in place, and they do really shape the way that police forces are, at least when they're bringing in the technologies, how they're viewing them and what they're doing with them initially. And they are actually, and the fact that there was, when police do depart from them, it's a very kind of powerful point of criticism as well, to be like, well, you know, you adopted this when you said this when you adopted this technology, and now you're going beyond it. So what we're trying to do with this project more broadly, just to bring it back a little bit, is to really kind of explain what, understand a little bit more clearly what each of these kind of checks and balances are able to do and what their shortcomings are, and then maximize what each of them can do. So anyways, and then I used drones as one example. We are also seeing in general in Ontario a very significant, we talked about a significant increase in CCTV cameras, but there's also a very significant uptake in drones. And so this is one place where we are really trying very aggressively to make sure that there are very clear rules that you can't overlay various types of AI analytics and other things onto drones, because we're moving very closely and rapidly to a situation where the restrictions on use of drones are now at the federal level, like you can only kind of use them in what's called line of sight, so where the officer can see where the drone is going. Those are being removed. There's a number of policing forces that are really looking to ramp up the number of drones that they have and start using them on a more like day-to-day basis. So we're going to start seeing police drones all over the place all the time. So that's one specific subset of areas where we're trying to make sure that there's really clear rules restricting the additional overlay of things like facial recognition and other types of video analytics to kind of mitigate, the ability to leverage these tools once they're adopted. But it also incorporates all these other technologies that my colleagues are talking about. To what degree are you able to centralize, the CCTV feeds that are available from a number of places? To what degree can you add video analytics that are, not just used ex post, which is a serious problem, to streamline and analyze all the massive amounts of video that police are getting, but even in live situations. So I think the Montreal police, Sûreté, announced like 2 weeks ago that they're going to be adopting a video analytics tool and it sounds like it might be applied to their live video cameras that they already control, and they're going to be doing analytics to try to see, one of the concerns is that they're going to be using these to try to identify in advance with AI whether like a crowd is, someone is becoming unruly, and then they'll get like a little alert. And then they do need to obviously, maybe verify that, or maybe they just send somebody over and things go from there. But that's a really like problematic way of turning what is a live surveillance capability into an analytical live surveillance capability with all the problems that come with that. So those are some of the problems we're trying to deal with. A lot of them are going through this lens of this project on police accountability, but we're also trying to find other ways to address some of them.
That's great, Tamir. I mean, again, some serious broad scope of work there. And I mean, in ways already from comments from each of our experts up here, there's sort of a common theme of challenges of oversight and accountability. I'll come back to that in just a moment. But another recurring theme in this conference is this notion that we're living today in this sort of unprecedented threat to global democracy, a rising tide of authoritarianism around the world, including our neighbor. And we're not free from it here in Canada. Of course, we have overreaching government bills like Bill C2, the Strong Borders Act, Bill S209, the Protecting Young Persons from Exposure to Pornography Act, which might have an age requirement that would be implemented. In light of that context, let me pose this question, and maybe you've answered this to some extent, so I'll add sort of a second part to it. What do you think is the biggest challenge to or for privacy and data protection today? And I get the sense that maybe oversight is part of that, but I'll leave that to each of you. So David, I'll come back to you.
Yeah, certainly. So I think that kind of in the background, or looming in the background, is this accountability piece and transparency, because certainly you brought up Bill C2. So Bill C2 is hopefully going to die on the order paper, but it has within it Part 15, which would require any telecommunications service provider or anybody who provides any sort of online service to essentially build into their systems intercept capability ready for law enforcement to remotely jack into, and the possibility of these sorts of secret orders. And this has come up in the past. We've seen it in a number of bills in different iterations and different versions, all of which have died on the order paper. And at no time have the police ever, or it's actually public safety and CSIS, ever kind of given a clear rationale for why they want to do this. And for example, the National Security Committee of Parliamentarians just issued a report a couple weeks ago related to this capability and said, oh yes, we agree that they should have it, but nowhere in there is there, in fact, the justification. And you wonder, like, where are they making the case for this to? And then you think about, okay, that's just one element. You think of the deployment of stingrays, these MC catchers. You look at the deployment of Clearview, facial recognition. And where in the system is there any systemic oversight and articulation of the need for this? Because certainly, you know, I'm not anti-police by any means. I think that in a whole lot of circumstances, the police should be able to satisfy a judge that the public interest in investigating a crime overrides this particular privacy. Like that's a feature, not a bug. That's exactly the way that it should work. But when it comes to the deployment of all these other tools, these also have much broader implications for the rest of the public rather than a particular targeted suspect, because so many of these are collecting huge amounts of information in a completely kind of untargeted sort of way. If you're doing analytics against video in a public place, you're doing analytics against video of completely innocent people walking in a public place. When you look at the tower dumps that police are using in order to get location information from cell providers, one of the leading cases on that, where the court said, hold your horses, it implicated at least 60,000 customers. So they had 3 suspects, so 3 bad guys, the rest of them were completely innocent people, and the police were asking for not only identifiers related to their cell phones, but customer names, addresses, account numbers, phone numbers, balances, billing information, all this other sort of stuff related to just this whole universe of innocent people. And in terms of law reform, so we have problems with Bill C2 and all that. If you look at every single privacy law that we have in Canada, in the public sector, which every police agency is subject to, in every single one of them, it says, governments, public agencies, public institutions, public bodies can collect personal information for the following purposes. Law enforcement. Like, it just says law enforcement. It doesn't, there's no conditions attached to that. There's no particular oversight attached to that. If it's for a law enforcement purpose, our privacy laws give them absolute carte blanche to collect information. And then on the private sector side, you look at the private sector laws, or the federal one, PIPEDA, there are checks and balances related to disclosure from private companies to law enforcement, but those really don't exist in British Columbia and Alberta's privacy laws that allow an organization to just kind of disclose information to law enforcement for law enforcement purposes. And where so much of the information that is of interest to law enforcement is not in my house, but is in the cloud, you want to have those sorts of checks built in as well. And I don't think the law has necessarily done a great job of keeping up. And I don't think, in some ways, like I think cases like Bajkovic kind of confuse things in terms of, what is a significant kind of privacy interest. And that's actually had a little bit of a backfire effect when it comes to kind of cybersecurity and investigating cybercrime, rather than kind of child exploitation online. And so I do think we need a broader conversation about really what is, in addition to the charter, what is the legal framework that should govern the use of surveillance enabling technologies, and which might be completely appropriate in some cases, but inappropriate in other sorts of cases. What are the circumstances under which these should be approved, rolled out? What's the accountability? Should there be reporting and a privacy impact assessment and things like that, or technology impact assessment to the Privacy Commissioner or to some other kind of arm's length regulator who doesn't have the same vested interest as the Chief of Police?
Okay, so accountability. So Andrea?
I agree with all of that. I think that one of the biggest challenges is that there are gaps between data protection and charter protection and other legislation that sort of comes into that mix. there's not, like, even the logic behind them sort of doesn't really mesh. And I think that's something that is a really, like, big project to sort of overhaul the whole way that we sort of address that, especially the role of technology in law enforcement. I also think a big challenge is that we do have this neighbor to the south that doesn't share the same protections that we do have in Canada, so sort of distinguishing the Canadian approach to some of these issues from the U.S. approach, and the public's perception of what's permissible and what's not is often very much colored by what they see on television or through the various means that they hear about them. So the ability to track people, like, the sort of big cases that sort of make the media, about being able to track, like, some person moving across the entire country, through the use of the, flock system that sort of compiles all of the license plate readers that are out there. That's like, and the UK does something very similar, being able to sort of, in the aftermath of a serious crime, be able to sort of say, well, this person, spent the last 2 days, moving across all of these state borders to finally arrive in New York to, randomly shoot some people. So that is a thing that I think also affects how we perceive of privacy protections here in Canada, and how the public, who's supposed to be participating in the democratic process of, making those kinds of changes, is confused, I think, about where we are and where we should be.
I also had privacy law reform on my list. I don't know if that's, but I do think it was very telling, and we have a very kind of sad thought experiment to the border of the South, I think, that's been playing out in real time recently. But I thought it was interesting that one of the first things that actually happened that was really problematic in the recent developments in the U.S., which I think has been taking a very abrupt turn towards more authoritarianism, was, and this is like a couple months back now, so it's hard to even remember, but one of the first things that the new administration did there was to appoint someone to consolidate data and break down all the silos across government, to centralize them. And it's not really clear to what degree, that was even successful, because there's a lack of transparency. But the fact that there was the fact that there was at least some semblance of a privacy law that was enforceable was at least a check in that context that slowed them down a little bit. And it's ironic to hear that the U.S. has a privacy law that was effective sometimes, because some of their privacy laws are not that effective. But in this instance, that this was actually something that was a little bit effective at slowing down the attempts of the so-called Department of Government Efficiency to consolidate data and collect it from different government departments and centralize it. There was another part of that where it's not clear, again, to what degree this was happening, but some of the impetus for this data centralization, some of it was to, profile people and streamline the government, and to make it more aligned with the objectives of the new administration using data, which is problematic. But there was also an impetus to, there was also the suggestion that the impetus was to use a number of AI tools to analyze that data. And to do that, you do need to centralize data before you can apply various types of AI analytics to it. So that's this de-siloing effect, which was, again, one of the first things that was done in the US and had some really problematic effects. I think it's very telling that this was, this is something that we should really be concerned about and and not wait until we're in a similar situation where we have, unfortunately, as it tends to happen in some democracies, unfortunately, an authoritarian-leaning government coming in. And the main vehicle at the federal level for preventing this type of data centralization is the Privacy Act. And this is one of the most outdated statutes we have on the record, to the point where even our Department of Justice thinks it needs updating, which is a pretty rare thing, because they're the ones, it's the government, it places limits on the government, and the government, the Department of Justice is rarely, going out of its way to call for restrictions on government use. So I think updating our Privacy Act is a very critical kind of component to making us ready for the next, for what's happening down the road. But as my colleagues have noted, we do have like more up-to-date provincial acts, and they're not quite where they need to be either. So like one example, and this goes beyond policing and authoritarian kind of leaning actions. You also need like a very more robust administrative framework, because like, and the example I have is that we're looking at is, so for example, the Quebec. So the way that the Quebec does actually have a fairly up-to-date data protection law on the public sector side, but we've had a couple of decisions out of the Quebec Privacy Commissioner's office that says that, well, if you're taking data that you already have and just feeding it to AI, so this is not like centralizing data, like assuming you already have access to it and feeding it to AI, that's compatible use. So like you don't need additional consent. You get around a lot of transparency mechanisms. One place where we saw this is the Quebec Ministry of Education decided to take information that the schools already had and just run an AI algorithm against it to start to try to predict who's going to be dropping out of school. And this is an algorithmic risk assessment mechanism that's been really problematic in jurisdictions in the US where it's been adopted. It's had some racial profiling elements to it, and biases elements to it. And it's led to students being, like, rather than operating the way it's intended, which is as an early intervention tool to try to help students kind of improve, it's instead, in many jurisdictions in the US where it was rolled out, it just confirmed a lot of really problematic biases that are already embedded into our education system. And the privacy law, I think, and we had parents, saying we don't want this for our students. But the privacy law was like, because of the limits in the way that our privacy data protection frameworks are framed, this is found to be something that the government can just do, and it's not a different enough type of use that it requires additional safeguards under that regime, and I think that's deeply problematic. I think a more like concrete proportionality assessment over everything that governments are doing in a data protection law would be a really helpful thing. Something that's actually enforceable and that you could take through the courts is one thing that I think would be a really kind of useful thing to have as we're moving forward into this brave new world of data exploitation.
That's, thanks, Tamir. And before I open things up and we move to questions also from the audience, we want to bring other people into the conversation. I realize we've been talking a lot about government use and abuse and law enforcement abuse and threats to privacy using technologies, and we've mentioned sort of the authoritarian sort of threat to ourselves. But one of the things we might think about the Trump administration is the persistent weaponization or combination of government power combined with private and technology power together, right? And so we haven't yet talked about private sector privacy and surveillance challenges. We are living in an era of surveillance capitalism and information capitalism, and this is again a theme that's come up in a number of other sessions where we're thinking through a world in which surveillance is a great way of making money, and our data is being collected by the private sector at unprecedented scale, and it too is being used and abused and weaponized against us. So maybe let me turn a little bit to the private sector context and ask this question to our panel. The government of Canada says it's going to break up its previously proposed Online Harms Act. And one of the justifications for the duty of care or the requirement of due diligence that was part of that proposal was, of course, privacy concerns. And maybe the question that privacy concerns about how these powerful technology platforms gather data about us, tailor services for us, but also use the data also for deception and manipulation and to exploit us for commercial purposes, but in other contexts, political reasons. We can see that in the United States. So let me pose this question. Do you think something like a duty of care, a duty of data loyalty, something like that, that kind of requirement should be imposed on private sector firms to protect privacy and data protection? Or is it really we just need updating existing laws? I know, David, you mentioned PIPEDA, which is, a statute for a different era, a different generation of challenges. So yeah, let me leave that open. We'll start with David. Go ahead.
Yeah, in some ways, I'm a little bit conflicted on these questions simply because that, to me, privacy is really at its core about individual autonomy and dignity and the ability to, be the person who makes decisions about my own personal information. And so as long as that's an informed decision, I want to always be the person who's in the driver's seat and not necessarily have a government tell an organization that, no, you can't do that, or put in place, too rigid guardrails that are put in place by somebody who's not me when it comes to my own information. And I've seen some things that are relatively paternalistic, and obviously children are a different category when it comes to things like that. And we've seen an increasing use, at least that I have, of our federal privacy commissioner using section 5 sub 3 of PIPEDA, which is like the privacy law guardrail in that statute, which says an organization can only collect, use, or disclose personal information for purposes that a reasonable person would consider appropriate in the circumstances. And the commissioner, of course, thinks that they're the reasonable person, and that's one of the reasons why Clearview AI was shut down, because it wasn't a reasonable purpose. So that's not a bad use of that particular power. But in other instances, it's the commissioner saying, oh, well, you don't get to do that. And people don't even get to make the choice about whether or not they use that information for those purposes. So I am concerned about some of the paternalism that could, particularly when you're dealing with adults who want to be able to make their own decisions. We do have in our kind of dusty old privacy law obligations related to transparency and organizations, and I don't think perhaps that's enforced enough in terms of making sure that organizations are completely transparent about how they're using your personal information, so that the things that are happening in the background, if you want to find out how advertising technology works, they will tell you. If you want to find out how their algorithm works in order to customize your feed, they need to be able to tell you. And so I think information is power in a whole lot of cases. And I would be afraid of politicians putting in place rigid statutory guardrails that would be fit for purpose a couple years before, that will be kind of governing technology and people's use of that technology for years to come. So.
Andrea.
Yeah, I mean, I think one of the common criticisms of data protection is that it is too individualistic, that it's about an individual having some sort of control over information that they kind of own or something like that, and that the collective interests that tend to be the ones that AI really produce, so the creating those categories and sorting people into categories and sort of assigning different sorts of characteristics to those categories, that's something that data protection can't really handle. And so I think doing that in relationship to the private sector, sort of finding ways of protecting people from the harms that can come from that type of use of the data is something that I think we're not equipped to do yet. I mean, I know that there's been talk in the other panels too about, how do we move forward with such a thing? Do we create a separate commissioner that's capable of addressing those sorts of things? And I think they would have to be addressing both public sector and private sector if they were going to do that.
Yeah, I think I agree with both my colleagues. There were some specific things, though, I think consent will always continue to play a really central role in any sort of data protection regime, because you do, at some level, have to take some, to some degree, there is an element of choice here, and to many degrees, people are kind of best placed to understand some. The context in which they're sharing some types of information and whether they want to share it or not. There are upper limits to that, and one of the challenges is that there's entire industries and entire disciplines that are just actually trying to find ways to create different consent mechanisms and system designs that will basically steer people towards making decisions that are not necessarily the ones that they want to make. And I think that's a really big challenge for this consent paradigm. I do think consent still needs to play a role. More transparency would be helpful. Some of the things that were proposed in the DSA and in the Online Harms Act that I think would be really kind of good to resurrect in particular would be are actually sort of procedural and transparency related. So giving people the right to appeal decisions that are made regarding to how their information is being, how their content, I guess, is really being used on platforms is a really helpful thing. But also giving research, in the DSA and in the online harms mechanism, there's also a tool that would allow researchers and other people to probe how information is being disseminated, including what personal data is being used when information is being disseminated on platforms in ways that isn't possible right now, because it's like every person can only see their own little kind of corner of what's happening when they're sharing information, and it's being disseminated, and the platforms have all the information on the big picture of like what's actually happening in terms of content being circulated and what personal information is driving that circulation and decisions around that circulation. And I think that would be a really powerful thing that transparency piece and accountability would really improve potential accountability for platforms and improve everybody's ability to really probe a little bit more independently how personal information is fueling the way that content circulates on these platforms.
That's great. And so now I wanted to open the floor for we have any questions from the audience. Of course, I have more questions for our panel, but I thought I'd just take a moment to see. Okay. Do we have a microphone? Great. We can. Thanks, Lucy.
Yes, good morning. Thank you very much for a very interesting, worrying panel. But so you gave a very good portrait, I think, of what's going on in the police sector. My question relates to the more private sector, employment sector. And I think the employees are really the weaker parties usually, unless they have a very good union. I just would like to hear, what are the implications of the, progress of technology in surveilling employees, and how is that dealt with under privacy laws or labor laws, or if you know?
Yeah, we're seeing almost exactly the same thing happening in the employment space that we've seen in the other kind of digital surveillance space, because cameras and technologies and monitoring technologies and key loggers and badge swipes and all these other sorts of things are information. You have a whole bunch of information that's collected, for not surveillance related purposes that can then be repurposed into that. So kind of back to work mandates. Some employers are using badge swipes in order to determine whether somebody is actually in the office, or, is their computer logged in through the VPN or not? So all these other sorts of things, information that is just part of our digital exhaust in the workplace is being kind of repurposed for these purposes. But in terms of the protections of privacy, there's significant gaps, because our federal privacy law only applies to federally regulated workplaces. And so you only have provincial privacy laws that apply in workplaces in BC, Alberta, and Quebec. And then the public sector has the public sector laws that are relatively weak, but there is oversight. But you mentioned if you're a part of a union, there's some interesting arbitral jurisprudence related to just a privacy right that employees have. And we do also see in those provinces where there is provincial regulation, a number of interesting findings from privacy commissioners and others related to kind of workplace surveillance that comes down to the same sorts of tests that we've had before. There has to be kind of reasonable purposes, there has to be proportionality and stuff like that. But it is interesting to see how technology is just, because it's gotten so cheap, like there's an interesting arbitration case out of British Columbia related to a logging company that had dash cams. And you start off with dash cams that are just kind of observing what's outside. Now dash cams observe what's inside. Now dash cams can have AI in them and can determine whether or not the person is drowsy and is showing behaviors of being drowsy, or whether they're smoking, or now whether they're the right person who is supposed to be driving that vehicle, or whether there are other people in the vehicle. So the technology has gotten cheaper and cheaper and cheaper and smaller and smaller and smaller, and so it could be repurposed for all these other sorts of things. And often enough we're not having kind of asking the questions about the function creep, that it might be completely appropriate in one context for like an armored car or something else like that, but perhaps not appropriate for like an Uber or a delivery van.
I just have a small thing to say about that. So another theme that's been through the different panels for this conference is about trust. And I think, so another component of this project that I've been working on is public perceptions of the use of some of these technologies and the degree to which they trust the people who are using them. And so I think workplace situations are similar in the sense that, you know, if there is a workplace culture that is using surveillance because there is a lack of trust between the management and the employees, that is a symptom of something that's a much bigger problem. And similarly with communities and police and, you know, government and citizens, you know, that you have this kind of dynamic that's about what's the purpose of surveillance. There are legitimate purposes for it when you're trying to detect, you know, actual wrongdoing that needs to be addressed. But you know, if it's a much broader kind of umbrella that is doing things that people that feel friction with, it's going to erode the trust, right? So I think that's parallel across all these different kinds of contexts.
Yeah, I think that's exactly right. And having a trusting environment where these discussions are had with employees before these technologies are adopted is really important. I think in many contexts, though, especially larger businesses, there's a lot of pressure to just do this. Like, and it started in other jurisdictions and it's making its way to Canada, but you're seeing it in Canada as well, where like, you know, if a lot of companies are adopting X, Y, and Z tools, and some of them are like efficiency tools, like monitoring, you know, like how many times did the employee type or whatever, or even task. Like there's AI tools that are doing like task assignment now, so it's like a within employment, like within different types of companies. So so if a lot of companies are adopting these, and there's the perception among businesses, and it's not necessarily borne out in reality, but the perception that this is going to improve productivity or efficiency, then there's a lot of pressure, like from shareholders and et cetera, to start adopting them comprehensively, and that becomes really difficult to push back from employees. And our privacy laws, again, have not really kept up in this space. Once again, Ontario is our biggest, most populated jurisdiction, and there's no like privacy law that applies to employees at all. So no vehicle for them to even voice their complaints, and that's a serious deficiency. The other kind of challenge, though, is even where there are privacy laws in place, is like what you're seeing in a number of workplaces is surveillance and AI mechanisms are being adopted for one reason, and often it's cybersecurity, especially when you have more remote work. But once they have that data, they also build in the ability to then like monitor it for other, like build in other types of monitoring considerations. So like in, you know, monitoring for inside threats is a suite of like employee monitoring tools that are AI dependent, that are just looking for abnormal employee behavior, and then that gets framed very, very broadly, and it also gets, and the outputs of that get worked into other types of considerations, like you know, not just task assignment, but also like, you know, decision making over who gets you know, not promotions per se, but like advancement and stuff like that. So it can have a really big impact in reshaping the way that the workplace is working, and it's not very transparent to the workers who are being affected by it. I do think that a more robust, again, privacy regime could be a very a very important additional tool for navigating some of these discussions, because you'll have an independent regulator that you can go to with complaints that can probe how these tools are operating, and if they're having, you know, if they're going beyond where they should be going.
Sorry to interrupt, but would labor norms could be improved to help workers?
I think like norms, like I think so, but the problem is how you get there, especially when there's pressure, like it's an international discourse, and there's other countries that are adopting these tools aggressively and then telling their shareholders that this is going to improve our productivity 8,000% or whatever it is. And so then the pressure to adopt these tools comes kind of top down, and having the norms in place is could be a very powerful way to push back against that. But I think to get there, we need a more kind of aggressive, an independent law reform mechanism to get there systemically. There's going to be businesses where those norms are already in place, and those are going to be more insulated from a lot of these developments. A colleague, the Ontario Information Privacy Commissioner, just commissioned a report that's audited, does an overview of a lot of workplace surveillance tools that if you're interested, and the AI that they empower, if anybody's interested in looking at it. It was just maybe a month and a half ago. It's on their website.
Sorry, and just one further note on that. So the only little sliver of privacy protection for employees in Ontario was recently added to the Employment Standards Act, related to requiring employers to have a workplace monitoring policy or statement if they have more than 25 employees. And they did that instead of actually coming up with a comprehensive privacy law.
Yeah. Sorry, I don't count that.
Thank you for
So it's
this
just a sliver.
very, very critical discussion. There's consensus, I think, that we need to modernize data protection, the data privacy and data protection framework. Do you think that this is the same, that this framework should also address the issue of deepfakes? And that here's why I want to bring deepfakes in our discussion. When you were talking about hacking of Internet of Things devices, David, I was thinking that, hackers could also mess with the content that this device is capturing. So that could lead to really serious implications when it comes to a person whose face is suddenly put inserted in there, for malicious actors. So is this the right approach through modernizing our data protection framework, that we need to also address this looming deepfake threat? And the other thing I wanted to say, it's just a comment. I was thinking about something I heard about recently. The city of St. John in New Brunswick is asking people to volunteer footage from their house surveillance devices. So that's a very interesting and odd case of public-private collaboration in surveilling our streets and neighborhood watch, etc. So it did give me a pause when I first heard it, and it's currently the program is currently being unfolded. So I just thought it would be interesting to share this with you here.
So private camera registries are all over the place. Yeah. So, you're constantly, I would say nearly every police service, at least that I've looked at, has some program for businesses, especially to sort of register their cameras with the police service so that if something happens, they know the cameras are there and where they are and that they can contact them. So, and yes, there's constantly calls for whenever there's any kind of incident, does anybody have dash cam footage or even cell phone camera footage, like that sort of collaboration between private individuals, private businesses, and policing is incredibly common at this point. It's like there's almost not even controversy about it, right? It's because of that sort of voluntariness, right? It's basically saying, it's my camera, it's my stuff, I can choose to share it. Or not. I mean, other than that police are concerned, that they're going to get whatever they can get their hands on. But yeah, I think that's a very common thing. But going to your deepfakes thing, so one of the things that I have been long interested in is whether or not privacy is the right framework for talking about things like identity integrity, right? So that it often gets employed that way because it's what we've got to work with. But, oftentimes people have been trying to reach for other things like, defamation or sort of other kinds of reputational protection, or your ability to sort of, the right to be forgotten was partly about that, to sort of say, I have this online persona that I should be able to correct, or I should be able to update, I should be able to have some more control over, how I'm presented to the public, which is not quite the same thing as privacy. So I'm still not sure that data protection is what's going to get us there. I mean, especially if it's not your image that's been misused, it's something that's been created by AI, say. And I know that we have to fix that, especially with the pornographic deepfakes. But yeah, I think it's an interesting problem.
Yeah, on deepfakes, I think our government has said that they're going to introduce. So we have whether I don't know if this will be enough, but we do have they're going to extend the criminal code provision that we have for non-consensual distribution of intimate images to apply to synthetic images. And there's also an international treaty that's was finalized a little while ago and is going to get signed at some point, which I think requires the extension of both that and the regime on child sexual exploitation material to synthetic content. So, but that's not. I don't think the criminal code is necessarily the best solution to these problems. Often, when you talk to people who have had issues with this, what they want is to get the content removed. They're not necessarily interested. So I think, and I don't know that the privacy regime is necessarily the one that's best. I think that requires a more kind of dedicated solution as well, maybe to address, because that's a very specific problem that you could solve in very specific ways. To the other, I forgot what was the first. Oh yeah.
Private individuals.
Yeah, the registries on yeah. So I think those are. I think those are going to. I think people feel comfortable with those for the reason that Andrea was saying, is because they still have control over when they're uploading the images right now. It's not like a centralized thing, which could happen eventually. And we see this a lot with Ring as well, where there's a feature where people can just kind of, and it could create problems with neighbors and that kind of thing. I think eventually, though, there will be some issues on the constitutional side, not necessarily for police, because our charter does protect the privacy of people who are. It's going to be an interesting question, I think, but if the police's theory here is that they're getting consent from the person who owns the camera, but they're not getting consent from the person who owns who's actually appearing in the image, and our constitutional right to privacy does kind of recognize that those people do have some sort of privacy rights. This is part of the problem with technological adoption in Canada. It's usually not very transparent, and it takes years, if not decades, before the courts start weighing in and put in place the actual principles. So I think these will be a feature of policing for a while, but eventually at some point there'll be some assessment at least, and hopefully some restrictions put in place.
And just on that, on the sharing video images, the very few police and very few businesses realize that at least under our federal privacy law, they can't disclose surveillance footage without a warrant, unless they are the ones who are themselves reporting the crime. And so, so these images of retail malls, blah blah blah, are routinely given to the police just on request, and which in most cases is contrary to our privacy laws.
Oh, two more questions. Yeah, go ahead. Oh.
Thank you. Thank you. Andrea, you addressed the first part of my problem, because I was thinking about how perhaps because we have privacy as this hammer, and so all the time we have to shape every problem into a nail. But then, so thank you about addressing that. But I'm thinking then about whether that framing affects public trust and public perception, because if we don't. And if you engage with the public, I think, if you do not, for instance, the example about sorting children into who's likely to drop out, if you frame that as a privacy problem, if you don't engage all of the analyses and scholarly analyses, it is very difficult to bring public perception to the place where they see that as a privacy problem, or even, and you referenced Bykovitz. Before now, it would be difficult to frame your IP address as a privacy problem. And so I'm wondering if perhaps the technology has moved on, but the culture has not caught up with what is now, I say privacy because that's the tool that we have. The culture has not caught up with what the harm is, because perhaps the framing, there's a mismatch between what the problem is and the thing that we're calling it, and the thing that is then happening in ways that we do not understand what's happening now. The public doesn't even understand what the technology is doing and what the harm is. And I'm wondering if that perception kind of builds trust or erodes trust in ways that's problematic.
I think that's a really interesting question. And I think that very often these issues arise and are associated with the use of personal information, and so it just takes on the characteristic of being a privacy issue, and privacy is the tool that we seem to have, and maybe we need to be developing more and better tools that maybe think a little bit more broadly. Or maybe we just need to be a little bit more multidisciplinary in our thinking about these sorts of things. Because I do sometimes find myself thinking that why is this a privacy? Why is the privacy person on this? Because it relates to bias, it relates to human rights, it relates to discrimination. But it's because it's the use of personal information that some privacy person jumps on it, and it says it's more readily identified as a privacy issue. And so I think probably in some cases one needs to kind of zoom out and think about things a little bit more broadly. Yeah.
Yeah, and I do think those, if the privacy analysis is done right, then those other considerations are factored in, and often the privacy analysis is not done right. So, like, if it's a use of information that's having, discriminatory impacts or is, is biased in various ways, that's something that should be taken into account when deciding whether the use of information is reasonable in a general way. Often that doesn't happen, so that is a problem. But you're right. There's these other tools that should also be playing a role. The Human Rights Acts in various provinces can also supplement in instances where they're implicated and have in some contexts in terms of addressing the overall some of these problems. But again, and we do also need some sort of broader AI regulator, as our colleagues were saying earlier this morning. I think that's absolutely important as well. For now, what we have is the privacy regime and supplemented with the Human Rights Acts where those are specifically implicated. So I think part of it's also that's the only tool that's kind of most readily available. And explaining that to the public, I think the public perception that we've seen is that people do often see it as understand to some degree that there is a connection to privacy if it's their information that's being used to make this decision about them. Even sometimes when the privacy law wouldn't necessarily, there's a lot of use of disaggregated or kind of de-identified information to make decisions that then affect people indirectly. So you de-identify a lot of the information. You do a general assessment that gives you a general understanding of a situation, and then you apply to a bunch of people. That doesn't usually factor in actually into the privacy analysis, but people sometimes perceive it as a privacy harm because their information fed into it. So I think the privacy concept still has relevant things to add to this discussion, but we do also need these other tools, and hopefully they'll come in place soon because there are gaps in how much it could do.
Jed, did you have?
I don't want to stand between people and lunch, so I can stop my question.
How are we on time? I know we started a few minutes late.
Sure.
Sure, okay.
I wanted to clear the floor, Jen.
Okay, thanks so much. So I guess my question builds on some of the previous questions and even some of the responses that were given to the last question. And I was wondering to what degree there might be a collective dimension to privacy law that needs further elaboration. And I think some of this has just come through in your comments, Tamir, about doing the assessment correctly when privacy complaints come in. But the reason I ask this is because it may be that people can turn to human rights codes to, have different types of concerns heard, and it may be that we need to turn to a more robust kind of building out of labor norms or even employment standards or workplace safety. But thinking about the freedom of association dimensions that come along with kind of mass surveillance, I wonder to what degree in rethinking our privacy regimes there ought to be an insistence on not just the individual importance of privacy, so the consent model and whatever, but the importance of privacy from this kind of collective perspective.
So that is one of the things that makes to me, the sort of municipal context really interesting, because there you do have sort of like a local community, and you have some mechanisms. You have a municipal council, you do have a police service board, you have like different sorts of mechanisms for people who live in that community to sort of communicate with their community leaders. And when they're implementing, greater CCTV cameras in their downtown core or something like that, there should be an avenue, for talking about them as a community, and not just like me as a person walking down the street in a particular town. So I think increasingly there's going to be like a need for those types of like local governance mechanisms to be able to handle these types of questions about, what the technologies that they're bringing into their communities are doing. And, are they ready to do that? Probably not, but there needs to be sort of more ability to sort of support those existing mechanisms, I think, also, like outside of the sort of big legislative mechanisms that we have to meet those challenges.
Yeah, I think I think a lot of people in privacy do spend some time thinking about kind of collective privacy rights and community privacy rights, and are talking about it more and more. First Nations data sovereignty is a topic that at least kind of privacy people are becoming much more aware of and attuned to, and I think more sympathetic to. But none of our privacy laws really contemplate. They're really entirely individual based. And you could think of it in terms of, and I know I've been on a data matching board for health research and giving researchers access to health information under a research ethics board framework. And among the questions we do ask is will this or could this have a potential impact on a particular community? And so I think those questions are coming up, but they're not framed in law yet. And it'd be interesting to have a conversation about whether one should do that, and if you decide yes, how you would do that.
I think the sort of our privacy laws are very individual consent based. There is also this overarching proportionality kind of framework that I think could be used to look at some of these decisions, some of these considerations, and bring them in. I don't think we're not really, the laws are not really set up to do it right now. And you would need like a different process, right? Like there's regulators that do public hearings and hear from people, and community decision makers that bring in people from the community. I think if there's a potential to kind of take this proportionality concept and maybe enrichen it, and then add like a lot of procedural mechanisms where you have consultations and bring in people from the community and have like actual discussions over what is and isn't acceptable, and then build it into this kind of proportionality assessment. But yeah, as my colleague said, we're not quite there yet, but there's the potential for it at least.
Yeah, it's a great question. I think it's like relational theories of data and privacy is sort of part of it, but even privacy scholars are just sort of coming to grips with this concept. But as David and Tamir and Andrea stated, it's really a challenge because we are still living within this sort of individualist, sort of informed consent model, and we need to start thinking about privacy in a different way. So we've covered a lot of ground, and I know everyone wants to eat and also get to a warmer climate. So I'll be very quick, but it seems like we need updated public sector laws, updated private sector laws, more than just a tiny sliver for employees, and new oversight and accountability. I think we could draft sort of recommendations coming out of just this one panel, but let me thank our excellent panelists for a great discussion.